Ready, start. When the Supreme Court of India passed its verdict in November 2019 in what is popularly known as the Babri Masjid case, it was a slight beacon of hope for all backers of the idea of India. Though the court ended up giving the plot of land to the party that was responsible for the desecration and demolition of the mosque, the court's glowing reference to the places of worship bracket Special Provisions Act 1991 was like applying a little balm to an embattled soul. It promised to shut the door with a finality on further contentions of other places of worship, notably the Gyanvapi Masjid in Varanasi and the Shahi Eidgah in Mathura. The unanimous view of the five-judge bench was in providing a guarantee for the preservation of the religious character of places of public worship as they existed on 15 August 1947 and against the conversion of places of public worship, Parliament determined that independence from colonial rule furnishes a constitutional basis for healing the injustices of the past by providing the confidence to every religious community that their places of worship will be preserved and that their character will not be altered. The law addresses itself to the state as much as to every citizen of the nation. The Places of Worship Act imposes a non derogable obligation towards enforcing our commitment to secularism under the Indian Constitution. Non retrogression is a foundational feature of the fundamental constitutional principles of which secularism is a core component. The Places of Worship Act is thus a legislative intervention which preserves non retrogression as an essential feature of our secular values. The light of peace and harmony burned bright, not for long though. Over the next year or so, petitions began to be filed for the so called liberation of Hindu temples where the mosques in Mathura and Kasi stand. These mosques have been on the radar of Hindutva forces ever since the Babri Masjid Ram Janmabhoomi agitation began, when the oft heard slogan was अयोध्या तो झांकी है काशी मथुरा baki hai. Bracket Ayodhya is a mere trailer. Kashi and Mathura are still left. The Kasi Mosque now faces almost 15 identical petitions. The Mathura Mosque has 12 petitions. More petitions have been filed in the lower judiciary against mosques such as the Shamsi Jama Masjid in Badaun, Tili Wali Masjid in Lucknow, Kamal Maula Masjid in Dhar, Madhya Pradesh, Adhai Din Ka Jaunpura in Ajmer, the Jama Masjid in Sri Gangapatnam, and even the Qutub Islam Masjid at the Qutub Minar in New Delhi. The claims of the mosques having been built after restructuring or demolishing ancient temples have been questionable. If, in the case of Badaun, the protesters were not sure whether the mosque was built after demolishing a temple or merely restructuring one. In the case of Kamal Maula Masjid, an idol was sought to be placed in September last year to buttress the contention that the mosque was an 11th century temple dedicated to the Hindu goddess Saraswati. There was no proof to back any of the contentions by little known right wing activists, but the petitions were still admitted in various district courts. Stop.